Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day. And we are here today with a strange addition to our sometimes series, Stupid Letter Time. We have covered stupid letters from various people, usually Congress, it seems, to various other people who don't seem to know what they're talking about. And today's edition, Stupid Letter Time, is a strange one for several different reasons. The first reason is that it is from a sitting federal judge. This letter, in the form of a law review, and I'll get more to what that means in a second, is from Judge Lynn Adelman of the United States District Court for the Eastern District of Wisconsin, a sitting federal judge. And this letter is also 35 pages long because it's in a law review. So I need to talk a little bit about what that is. Law reviews come in many different varieties, but they are the professional publications for lawyers. These are, they can be thought of as the scientific journals, if you like to talk about that. But they don't all have to be in that same vein. There's a lot of different ones, from very rigorous ones to not so rigorous ones. But they come in a lot of different varieties, and they can be very, very influential. And one of the things that shows how influential this is, at least in my view, is when you talk about, for example, the Second Amendment. Everyone knows Heller, everyone knows McDonald, right? These cases. But the rationales or theories that underpinned those cases came from law reviews. Perhaps most notably from starting the ball rolling from a law review printed from Yale Law School in 1987, which was called The Embarrassing Second Amendment. And by this, the author meant that people treated it as embarrassing, not that it inherently was embarrassing. Before this law review came out, the general consensus was that the Second Amendment only applied to groups, didn't apply to individuals, and that the government could regulate it pretty much how it liked. That was the case law as it existed at the time. And this law review that came out in 1989, that came out, was the start of the change of that. This was by no means the only law review. Basically, what happened after that law review article came out, the lawyers started arguing about it in the law reviews for the next 30 years or so. And as a result of that debate in that academic sort of way, that's basically where Heller and McDonald came from. So these things can be majorly influential. They can also be more opinion pieces, and that is more true for what we're looking at today. This particular law review article is being published in the Harvard Law and Policy Review Journal. This is the official journal of the American Constitution Society, which is a progressive legal organization, which is not to be confused with the very similar named Harvard Law and Policy Review. The Harvard Law and Policy Review is not to be confused with the Harvard Journal of Law and Public Policy. These are two different things. The Harvard Law and Policy Review is liberal. The Harvard Journal of Law and Public Policy is conservative. Very similar names, but they are different ideologies. And Harvard has many different things of this. My law school had 3 of them. I was privileged to be an editor-in-chief of one of them, the Intellectual Property Journal, as you might expect. And, we took our job really, really seriously. So we're going to read this and respond to it. She is criticizing effectively her boss. She is a district judge criticizing the sitting Chief Justice. So that's just super exciting. So let's read this and comment along the way. By Judge Adelman. By now it is a truism that Chief Justice John Roberts' statements to the Judiciary Committee that Supreme Court's justices' role is a passive one of neutral baseball umpires who merely calls balls and strikes was a masterpiece of disingenuousness. Well, we're off to a real promising start here. It is a truism, right? It is a truism. It is axiomatic, to put it another way. It is so baseline, it requires no argument whatsoever. As a result, I will offer none. I will offer none because it is self-evidently axiomatically truism that it was disingenuous. Right. Okay. Rather than like, also like you do understand that a baseball umpire calling balls and strikes, even though it's relatively passive, will have massive impacts on the outcome of the game. Probably for the right if they're doing their job right. So to say that you're an umpire and you just call it like you see it tells you nothing about like what the end result would be. So I would say it's a truism that, just because the score of the game is 13-0 doesn't mean the umpire had it out for you. If that's really what it should have been, it really what it should have been. So if they're reaching particular results because they should have reached those results, that doesn't make them non-umpire-esque. And just because they're reaching particular results doesn't mean they're not being an umpire. If they really did strike out that many times, well, what are you going to do? Roberts' misleading testimony, because it was disingenuous, which I would like to note implies heavily intent. Roberts' misleading testimony inevitably comes to mind when one considers the course of decision-making by the court over which he presides. He is also one member of the court over which he presides, and he has no extra power to do stuff. His power is relatively limited. He gets a little bit of power in terms of assigning who gets to write opinions, but his vote counts just as much for anyone else's. So, there's that. At this pace, this 35 pages is going to take a long time to get through, guys, so strap on in. This is because the Roberts course has been anything but passive. Again, going to the umpire analogy. An umpire being passive tells you nothing about what the result of the game should be. The score might be 3-3 and the score might be 30-0. It tells you nothing about the relative passivity or honesty of the umpire. Maybe it really was 30-0. Maybe your other team just sucks. Rather, the court's hard right majority, well, I could actually counter that empirically. We've looked at these graphs before. The court is not hard right. And it's certainly not a hard right majority. No. Is actively participating, undermining American democracy. Okay. Indeed, the Roberts Courts has contributed to ensuring the political system in the United States pays little attention to ordinary Americans and responds only to the wishes of a relatively small number of powerful corporations and individuals. I really don't know how that's possible. Maybe she'll tell me. Because courts do law, not politics. So I'm not really 100% sure how a court could have any influence on what the political system does vis-a-vis they're paying attention to certain groups versus certain other groups, right? Because courts don't do law. I apologize. Courts don't do politics. They do law. So I'm not really 100% sure how it's possible for a court to ensure the political system pays attention to anything. That's not what courts do. Courts do law, not politics. So maybe she'll tell me how it's possible. That'll be enlightening. As Columbia Law School professor Tim Wu explains, about 75% of Americans favor higher taxes for the ultra-wealthy. The idea that federal law would guarantee paid maternity leave attracts 67% support. 83% favor strong neutrality rules for broadband, and more than 60% want stronger privacy laws. 71% think we should be able to buy drugs imported from Canada, and 62% thinks that Medicare should negotiate for lower drug prices. Like the list goes on. I think I like. Did you get lost? Did you get lost? Do you not know where Congress is? I could give you directions if you want. What you need to do is go out the main door and actually, literally in this case, walk across the street, because we're talking about the United States Congress. It's actually literally across the street. Normally at this point in the joke, I say turn right and go a half mile down the street. But in the case of the United States Supreme Court and the U.S. Supreme Court, what you need to do is literally actually go out the main door and just keep going. Just literally go out the main door and just keep walking straight. You'll walk right into the Capitol. There's nothing in between you. You'll walk right into it. All you have to do is literally go out the main door and just keep walking dead straight. You're there. No problem. It's right across the street. Did you get lost? Try again. I have no idea what this has anything to do with courts. These sound like interesting policy ideas. Talk to policy people. Don't talk to the lawyers. Don't talk to the courts. That's not what they do. Of course, one cannot blame the Roberts Court for the fact that in numerous instances the will of the majority is ignored. That even like presumes that that's necessarily bad because we live in a republic, and you can make a credible argument that a politician should be willing to do things that their constituency doesn't necessarily like. Normally, you'd say that's like really brave in character, right? So just because Congress is defying the will of the majority, it doesn't necessarily mean that they're not necessarily doing their jobs based on what you view of like the proper role of Congress vis-a-vis the people, right? Just because 60% of the people want something doesn't necessarily mean Congress should do it, right? Presumably, like they should be able to, yeah, okay. The fault for the state of affairs is primarily with Congress. Yes, that's who does politics is Congress. You're right on board. But it's also true decisions of the Roberts Court are contributing substantially to the fact ordinary Americans have so little political power. Okay? In at least two critical respects, the court's decisions are undermining the democratic republic that the American people, often by subordinate groups, have fought for. Okay, and this is happening at a time when democratic institutions need strengthening. I'm not really sure, like, how. First, the court has decided a number of cases which, taken together, constitute a direct assault on the right of poor people and minorities to vote. Wow, she has a little bit of bias here. For example, the court has weakened the Voting Rights Act and landmark civil rights law. Okay, well, that's actually a valid point. You can make a very credible case, even from a conservative perspective, that decision was wrong. So I'll give you that one. If you want to say that the court's decision in the Voting Rights Act case was wrong, even under conservative principles, I'll allow you that. In addition, it has upheld strict voter identity laws. Yeah, because there's like nothing that prohibits it. As well as states authorizing thousands of purges from voting rolls. I'm going to facepalm now. There is a federal statute passed by Congress that requires the states to purge their voter rolls. It's an actual law passed by the actual Congress, the actual democratic institutions. They passed a law that actually requires the states to purge their voting rolls. It's an actual law. Basically, what it says, without me looking it up really briefly, is like, if you don't show up to vote for a long enough period of time, and I think it's like 2 elections, it's been a while since I read it, then the state has to send out a couple notices by mail. And if you then don't show up to the next election after that, then they can strike you from the rolls. The idea being that you have moved or you're ineligible or something. But there is a law that actually requires this. So, they upheld it because Congress, the democratic institution you referred to, passed a law specifically requiring them to do it. And somehow it was a 5-4 vote from the U.S. Supreme Court, which I'm not sure because it was pretty plain on its face to me, but okay. Further, has failed to rein in any anti-democratic practice of partisan gerrymandering. Well, maybe she'll get more into this later, but the problem there was the judiciability standard. At least as it seemed to me. As I'm sure she well knows, as I try to mansplain law, I guess, as I'm sure she well knows, the U.S. Supreme Court had been putting out feelers for 2 decades or something, basically saying we'd really like to do something about gerrymandering. Can anyone give us something that we can actually administer? And they kept trying, and basically nothing worked. And so they basically said it was unadministratable, and so therefore is non-judiciable. So, yeah. The second way in which the court's decisions have undermined democracy is they have unfailingly increased the economic and political power of corporations and wealthy individuals and reduced that of ordinary Americans and entities which represent them, like labor unions. talk to Congress. That's what Congress does. Yeah. Lynn is the guy. Judge Lynn is the guy. Okay, well, sorry to Judge Lynn. It does say he in his footnotes for pronouns. So I apologize for misgendering you, Judge Lynn. That was unintentional. Sorry about that one. You did put he in your footnotes. Well, one can perhaps take some comfort in the fact that my default assumption was that it was a female federal judge. So hey, at least my biases were such that I not just assuming it's male. I actually assumed it was female. So that's progressive, right? Because I didn't just assume it was a male writing it, I assumed it was a female writing it. So that's progressive, right? That's how that works. I don't know. In this article, I explored the decisions of the Roberts Court in these areas in more detail and discussed why they're so harmful. In section 1, I provide some background in order to situate the Roberts Court in a historical context. I talk about how in the last third of the 20th century, in response to a number of economic and political developments, including the egalitarian movement of the 1960s, corporations and wealthy conservative donors began to invest large sums of money in promoting conservative ideas. So conservatives promoted speech to promote their ideas. Okay. At the same time, a conservative legal movement emerged and provided the context by which all members of the Roberts Court conservative majority came of age. Well, that's actually largely true. When was the Federalist Society actually established? Because it wasn't that long ago. And it was established at Harvard, which is funny, too, because it's super conservative. Well, not super conservative, but it's conservative. It was founded in 1982. So yeah, it's relatively new. So yeah, it was one of the things that got this movement off the ground for conservatives. Like, yeah, the Federalist Society was big. So the students that started that at Harvard in 82, man, they really got their money's worth for that. I note that in conjunction with several other developments, the conservatives' aggressiveness, as opposed to the progressives' assertiveness, presumably, has contributed to causing economic and political power to become increasingly concentrated at the top. As a result of concentration, government policies become less and less responsive to the needs of ordinary Americans. There is no way I'm making it through the entire letter, both on the basis of my own sanity and based on our pacing. We're on page 3 of 35. There's no way we're going to make it. We'll get as far as we can, and then we're going to give up. I point out under these circumstances, it would be highly desirable to have a Supreme Court that could at least play the role in righting the ship, as the Warren Court did in the 1950s. Presumably, you want them to right the ship by making judgments that are more to your personal political likings, rather than in compliance with the law, but okay. And 1960s, when it addressed such long-standing deficiencies as segregation, malapportioned legislative districts, and brutally unfair criminal justice. Rather than counteracting anti-democratic trends in the country, like what? What anti-democratic trends? The Robert Court reinforces them. I briefly discuss some decisions of predecessors, such as Berger and Rehnquist, that foreshadowed the approach. Right. So he is correct in that respect. He is correct in that respect. Of course, they've been foreshadowed, because this is something that's been developing and developed. So yeah, in the 1960s, the conservatives started speaking up. 1982, the Federalist Society was formed. And, the conservative legal thought has been sort of germinating ever since. So yeah, as it became more and more adopted as a way of thinking, it's something that has percolated throughout the court, sure. $10 from El Rio Grande. Thank you very much for the super chat, El Rio Grande. Conservatives actually have to spend money to speak. Yeah. It's kind of hard to take them seriously when they reason money even has to be involved. Stop censoring conservatives, problem solved. And, I will divert slightly here. To say that Bloomberg's flameout is as much proof to me as anything that Citizens United was correctly decided. Now, Citizens United wouldn't have affected Bloomberg either way, because it wasn't a PAC or super PAC. It was his own money. So Citizens United as such wouldn't have prevented him from spending money or allowed him to spend money. What I mean by that is that what I meant by it proves that it was correct was all the people who said Citizens United was wrong, among other criticisms, they said that if you allow unlimited money to get into elections, people will just buy elections. This is why Citizens United is bad, because it will allow people to buy elections. Well, Michael Bloomberg proved that, that just doesn't happen so much. If we needed proof that you just can't buy elections, Michael Bloomberg proved it pretty well. So, all the people who criticize Citizens United by saying, hey, this just means that people can buy elections. Well, it might exhibit 1, Michael Bloomberg. Yeah, how did that buying elections thing turn out for you guys? Yeah. Also, in the case I need to point it out, Hillary Clinton also spent more money than Donald Trump, and Donald Trump is president. So money doesn't exactly meet equal votes now, does it? No. All right, background. Tell me more about this background. That'll be good. A government loses its character when its leaders stop devoting their efforts to benefiting the public, including a large number of people who have little economic power and instead serve the interests of a minority, the relatively few individuals and corporations who, through financial and organizational support, play a key role in keeping the leaders in power. This goes to philosophies of government that are pretty deep here and definitely doesn't really speak to the courts. $2 from Zex, Super Chat. You can buy a politician, not an election. I'm not 100% sure you can even buy a politician, Zach, for the same reason. Not the least of which is a lot of people are trying to buy him. So there's that. The problem is twofold. Runaway incomes at the top of earning scales and widespread income stagnation. This has very little to do with courts. Between 1973 and 2007, the top 20, I don't care. I don't care because these are all policy issues. This is policy. This is policy. Go talk to Congress. That's what they do. 78% of Americans work full-time, paycheck to paycheck. Go talk to Congress. That's policy. While it might be arbitrary to assign a date to the beginning of the shift towards concentration of wealth, one could do worse than the year of 1971. Sure. I have no objection to this. You want to pick an arbitrary date? Fine. 1971? No problem. 2 months before he was appointed to serve, Powell, then counsel to the Chamber of Commerce, wrote an infamous memorandum arguing the American economic system was under attack and the Chamber and corporations need to respond by becoming much more politically aggressive. So he used his freedom of speech to tell people he thought would be aligned with him, hey, we need to get more politically involved. Why is this bad? I don't know. It's a problem. Apparently. Reacting to the egalitarian legislation of the 1960s, the decisions in Warren Court, and social upheavals of the same decade, Powell argued business had to organize and engage in political activity. There is a First Amendment last time I checked. He also asserted the courts may be the most important instrument for social, economic, and political change and offered a vast opportunity for the chamber. Okay. At about the same time, conservative activists began creating and funding right-wing political and legal organizations. Presumably, you have no objection to the left-wing who created left-wing political and legal organizations, do you? You have no problem with the progressive activists who funded left-wing political groups, just the conservative ones who funded right ones. Conservatives raised large sums of monies and fought legislation favorable to unions, working people, and poor. So they petitioned for redress of grievances, and they used money to spread their ideas and gain political power. They also developed an aggressive litigation strategy regarding a variety of constitutional and economic issues and sought to undermine previous Supreme Court decisions. Well, again, not to point an obvious finger here, but the progressives did exactly this during the Civil Rights era too. They deliberately came together to fund and forward a very aggressive legal agenda. So why is it bad for the conservatives but good for the liberals? Does anyone happen to know? Because I don't. For the record, I have no problem with left-leaning groups or left-leaning causes existing. I believe in freedom of speech for everybody, and if you're left-leaning, you should be able to support your people too, even if that's Michael Bloomberg, which apparently none of you do because he didn't get any votes. But in a theoretical world, you should be allowed to support him if that's what you want. Over the years, the success of business groups, trade associations, and right-wing advocacy groups in raising money was in such a large imbalance in wealth and organizational resources developed by the conservatives who sought influence. Well, we were at a disadvantage at the time because the left-leaning progressive stuff was already in place. So we were the underdogs at the time. So there's that. I thought you guys liked it when the underdog fought. The conservatives also had considerable success from a policy standpoint. That would be, for example, passing laws. That would be what that means. And government became increasingly responsive to a relatively small number of individuals and corporations, unresponsive to the majority. So the conservatives were able to get the votes they needed to get their policies preferred. Also, the way people answer things on polls and the way people vote are not necessarily the same. The Republican Party has been particularly afflicted by concentration of wealth at the top, as opposed to Democrats. I think you guys have a lot of wealth at the top of your party too. I feel like it's fairly concentrated at the top of your party too. I'm not sure if it's more concentrated or less concentrated than the Republican Party, but it's probably pretty comparable. The party's political agenda is now determined by a small and unrepresented number of individuals, as opposed to the Democratic Party. Hello, superdelegates. President Trump's behavior after being elected elicits this. Although he ran as a populist and promised to promote policies that benefit ordinary people, well, up until like this week, we have been in the most booming economy ever, with the lowest unemployment and so forth and so on. So, I don't know, feels like he benefited ordinary people pretty well. Upon taking, Trump almost entirely reversed course. Again, up until yesterday, unemployment was at an all-time low and the Dow Jones Industrial was at an all-time high and the economy was great and things were booming and the lowest black unemployment, lowest minority unemployment, highest woman employment, so forth and so on. It was all great. Go back to the State of the Union and just see what he said. It was all true, despite what Pelosi said, where she ripped it up because it was a bunch of lies. What lies? I still want to know, because it was all true. All those things were true. Trump, you don't have to like him, but he presided over a massive economy, and now beer disease is going to kill us all, but that's okay. He appointed mostly wealthy far-right Republicans. Well, that is one of the things he gets to do, is appoint people and their supporters to his cabinet and key positions in the administration, and supported healthcare legislation drafted by conservative legislature that, had it been passed, would be extremely harmful. So yeah, $5 from Zex. Thank you, Zex. Democracy equals mob rule. A little bit, yes. That's why we live in a republic. Voting wasn't meant for everyone. You had to own property. Well, originally that's certainly true. Also, 90% of the rich districts are represented by Democrats. I definitely believe that's true, yes. I definitely believe that's true. So yeah, yeah. And then £5, presumably from Torah. Thank you. Clinton working with Russians to influence the election via Steele dossier. Okay. Trump not colluding with Russians, prosecuted him for it anyway. A little bit, yes. A little bit of those things. Thank you very much for your super chat contributions. It really does help us grow. And I, the Republicans are entitled to an opinion just like the Democrats are. The Republicans are entitled to promote legislation. And if it passed and been signed, it would have been law because, I'm just a bill. Yes, I'm only a bill. Sitting here on Capitol Hill. Okay. Trump also supported a tax bill that provided big benefits to the company's largest corporations and wealthiest, and virtually nothing to the majority. Well, once again, record low unemployment, record high minority employment, record high women employment, record everything. So, I don't know. Feels like it helped a lot of people to me, but, I'm a dirty Republican, so what do I know? I'm just going based on numbers and facts and realities that actually exist in the real world and are demonstrable. you know, quantifiable and objective. These are realities. These are the numbers. These are how they are measured. These are what they are. They were at an all-time high. Didn't help anyone, though, who was in the minority. Okay. Trump also promised major infrastructure programs to provide well-paying jobs to workers. However, he's not followed through on this promise, largely because it would require considerable increase in domestic spending, which influential Republicans oppose. Well, I will give her. I apologize, him. I keep saying her, because I just assume federal judges are women because I'm progressive and I want to make sure that to not misgender people, but it's a him. But yeah, infrastructure improvement could use work. I don't think it's a particularly good way to infuse the economy with cash. So I don't think it's a particularly good way to inject money into the economy. But on its own merits, in the sense that bridges and such could be repaired, fine. Yeah, so that's a valid point of criticism, sure. Also, you do understand that just because Trump won something doesn't necessarily mean the Republicans as a whole won it. And once again, they have to pass laws. So if, Republicans as a whole oppose it, then it won't get passed because that's how laws work. Because congressional Republicans depend on a relatively small number of wealthy donors, as opposed to Democrats, really, their majority public policy goals do whatever it takes to make such donors happy, as opposed to Democrats who do whatever it takes to make their donors happy. Are Democrats actively trying to irritate their donors by contrast? And Republican donors are mostly interested in tax cuts, fewer regulations, and less spending on anything benefiting ordinary Americans. Again, I feel like, she should probably look outside once in a while. Ordinary Americans have been doing pretty well. And Trump, who has few commitments to substantive policies of any sort, found it much easier to align himself with congressional Republicans. In other words, politics. Politician finds politicians to align with, film at 11, to make it easier to enact policies. To follow this through on a populist campaign would have required him to engage in difficult and unpleasant work of bucking his own party. Well, they also have a slightly different idea than you do of what populist means. I tend to think that Trump has, on the whole, been more populist than not. He's been populist conservative, but, it's been populist. Thus, while Trump's temperament is that of an autocrat, he is disinclined to buck the wealthy individuals and corporations who control his party. Presumably, an autocrat would be inclined to benefit those people, not disinclined, but okay. There is no way we're going to make it. Maybe we'll make it through the introduction. We're on page 8. There's no way we're going to make it. For some of the same reasons that has been focused on more For some of the same reasons that has become more focused on serving the wealthy, the Republican Party has also become more partisan, more ideological, and more uncompromising. Different graphs just to look at that different ways in terms of when you look at graphs and say like how much have conservatives changed versus how much have Democrats changed. Quite a few of these graphs I've seen, at least, have suggested that Democrats have become more left-leaning than the Republicans have become right-leaning. But, maybe she's looking at different graphs. Furby Slayer gives me $2 and says, even smallest dollar, irrational donor, grassroots. Yep, absolutely. This is particularly true of matters regarding the judiciary. A good example of this was in the response to President Obama's nomination of Merrick Garland to the Supreme Court. Notwithstanding that Garland was a moderate nominated well in advance of the next presidential election, Republicans used the majority in the Senate to prevent consideration. Yes, they did. It was perfectly legal. It was a very, very risky move, too. It was extremely risky move. And at the time, I was more than a bit dubious because, the odds strongly favored Hillary Clinton getting nominated. And the odds would be that she wouldn't appoint Merrick Garland, right? She wouldn't just keep the same nominee. She put her own person on. So I felt like it was a really dangerous game. The Republicans won it, but man, oh man, that was risking a lot. But they tried. They did it. The zealous partisanship of the Republicans, displaying connection with Garland nomination as well as judicial appointments generally, reminds one of nothing so much as the fire aiders, those fervent defenders of slavery who pushed the South in the Civil War. Well, I know it's not quite Nazis, but nevertheless, I'm going to declare Godwin's law invoked. It's not quite Nazis, but nevertheless, I'm declaring Godwin's law invoked. She just compared the Republicans to pro-slavery people. She just compared the Republican Party and their move. Apologize. He just compared the Republicans to slavers. I'm just going to read that again for us all to really just sink that in. The zealous partisanship the Republicans displayed in connection with the Garland nomination, as well as judicial appointments in general, reminds one of nothing so much as the fire eaters, those fervent defenders of slavery, read Nazis, who pushed the South into the Civil War. I'm just going to stop reading. I'm going to stop reading because Godwin's law has been invoked. Godwin's law has been invoked, and so the argument is lost. That is Godwin's law. You have compared the Republicans to slavers, and the argument's over. So that was super exciting. End of argument. Well, we all enjoyed that 8 pages, didn't we? Of just wow. But we actually literally invoked slavery, and we said that the Republicans. We said the Republicans and their zealousness displayed in response to the Garland nomination was just the same as the pro-slavers. $2 from Zek says, which party had internment camps again? That'd be the Democrats. Yeah. That'd be the Democrats, yeah. FDR. Korematsu. Good times. $5 from Furby Slayer says, he's calling the Republicans zealous, yet the DNC is literally melting down. Rose-colored glasses. Much. You call the Republicans Nazis. You call them slavers, but wow. Wow. I feel like I have to keep reading just to see what happens next because it's so horrible. I can't look away. I'm such shock. I would like to remind everyone at this point in the stream, this is a sitting federal judge who's writing this. So let's just all fully comprehend exactly what that means, because I think it might have passed some of us by. I just want to fully comprehend exactly what that means. All right. Sitting federal judge. What do judges do? Judges judge things. Judges evaluate things. Judges try to figure out if, like, some things, based on facts, meet things, other things, right? So judges use judgment, right? This is a federal judge who's using judgment. In their judgment, the zealous partisanship the Republicans displayed is the same as slavery. This is their full-time professional job. Judging, evaluating. This is the conclusion they've come to. Wow. Wow. $2 from Zach. 90% says this Marxist intern he's banging wrote this. Very cute and not exactly impossible. Yeah. Wow. All right. We're going to press on a little bit, but geez, oh Lord. I don't know why I'm reading and taking anything this person says seriously anymore. Under these circumstances, it would be beneficial if the Supreme Court were interested in doing what it could do to counteract. Why would the Supreme Court want to do that after you just called the Republicans slavers? You know, some of them are Republican. Just, you know. Wow. As mentioned in the 50s and 60s, when gross inequalities and injustice became so stark, they could no longer ignore, the Supreme Court rendered decisions that attempted to address it. This included such decisions as Brown versus Board, which was based on the 14th Amendment, and Baker versus Carr, which attempted to equalize political power of citizens, resulting in different communities. Baker versus Carr was a very big decision and not well known. And if you know, to the extent you want to say the Supreme Court has become too partisan or too political, to the extent you want to make that argument, you could probably point to no other case other than Baker v. Carr, which was a progressive decision that allowed that to happen. It ostensibly dealt with whether or not members of the Senate in Tennessee had to be equally divided in the state Senate. But it opened the door to politics in a way that nothing ever had before. So, if you want to blame the court for being overly political, the progressives kind of started that one. It was Baker v. Carr. $5 from Trent Dow says, for a beer you're going to need after this. I'm going to need many things, Trent. And Gadian versus Wainwright, which attempted to reduce the importance of a criminal defendant's financial resources by requiring counsel be provided to a defendant. Yeah. Which is also a pro se case. It was pro se before the U.S. Supreme Court. It was handwritten. It was a handwritten appeal on prison stationery, and they won. I love that story. It's a great one. Unfortunately, the Roberts Court does not play a comparable role. They're not legislating from the bench, that's true. As the Republican Party has become more conservative, again, debatable, so have the conservative justices appointed by Republican presidents. Again, very, very debatable. Very, very debatable. Rehnquist was more conservative than Thomas when he was first appointed. And, neither Kavanaugh nor Gorsuch are particularly conservative, in a objective scale. We've seen charts on this before that have tried to do this objectively, and they're just slightly above moderate. So neither of them is overly conservative. So there's. Rather than attempting to counteract these trends, the Robert Court exasperates them. Before discussing these specific decisions, however, I want to briefly mention Berger and Rehnquist. Sure. I previously noted that two types of decisions have played a significant role in making the system less democratic. The first type involves cases that constitute relatively direct assaults on democracy, such as voting rights. Probably the most prominent example of this was Bush versus Gore, a 2000 decision of the Rehnquist Court in which the court's 5-4 majority ordered a halt to the counting of votes and awarded the presidency to the Republican candidate. Legal scholars are virtually unanimous in agreement there was no legal basis for the court's action. Okay, if you say so, I will note there's no footnote. There's no little. You see how there's no little number after that period. There's no little number after that period. So citation needed on the virtual unanimity of that citation needed. Decision appears by most observers to be entirely political, as opposed to the Contra decision, which would have not been viewed as political, I'm sure. The court itself reinforced the provision what said its holdings in the case should not be treated as precedent. Yeah, it was what we call in law sui generis. I'm not sure that the court actually used that term, but basically it's self-generating, right? It's a case of such unique circumstance that kind of sits outside the normal legal framework. So it was weird, and I'm not 100% sure the court should have taken the case. Personally, I think there was a pretty credible argument that it was a political question. To the best of my knowledge, none of the justices said it was a political question. But I think you couldn't have said it was a political question, and then you would have just said, well, Florida figure it out. And when the result would have been exactly the same. So I don't know that it would have mattered either way, but I think the court was probably better off in saying it was a political question. Or at least analyzing it, because I'm not sure they analyzed it. As we'll see, many of the court's decisions involving voting rights demonstrate a similar disrespect. It's worth noting that then attorney John Roberts, now Chief Justice, played a significant and little role in assisting Bush's forces. That's true. He was, what is he, like White House counsel or something like that at the time, or assistant White House counsel? So yeah, he wrote memos that were very helpful to the conservatives because that was his job. The second type of decisions that contributed to the weakening of the American democracy involves cases that are not directly political, like voting rights, but which contribute to economic inequality, making it harder for poor and working people to improve their economic circumstances. I don't know. Feels like Trump has been doing pretty well in that. People have money and can buy things and stuff. These cases have a strong impact on democracy because, as I'll discuss, the viability of American democracy is highly dependent on a popular sense of shared burdens and shared prosperity. One of the most important decisions of this type was the Burgers 1973 case of San Antonio versus Rodriguez, in which the court's 5-4 conservative majority upheld a school financing system in Texas for which every 1,000 the state sent to wealthy districts, it sent only 370 to poor districts. Okay. The court held squarely that students in public schools had no constitutional right to an equal public education. Well, you're talking about different districts, right? And so, that might be an issue of state province or not. And, should all schools statewide be, funded exactly the same level or not? I mean, you could make a credible case. I think you could make a credible case it should go the other way under some sort of equal protection argument. So, you could make a different analysis there. So that's a fair point of criticism. I don't know that I would agree with it, but at least you can make a fair point of criticism. The extraordinarily pinched and narrow understanding of the concept of equality. Wow. So now this becomes an issue of what do we mean by equality, which is always fun. What do we mean by equality? Equal in what respect? Good. In an eloquent dissent, Justice Thurgood Marshall argued the government had to treat all citizens equally. Yes, but what exactly does that mean? And questioned how the judiciary in a democracy that was supposedly committed to equality could uphold the Texas system. I don't know that I've ever read the case, so I'm not really in a position to make a strong opinion on it. I can't read every case. There are a lot of them. Marshall knows that the discriminatory expenditures at issue seriously impair the ability of poor people to participate effectively. It is also important to mention the 1978 Burger Court of National Bank versus Belton, which dealt with a Massachusetts statute prohibiting corporations from spending money to outflame state referenda that did not directly affect their business. This would be the flip side of Citizens United. This would be what Citizens United was undoing. In part, was Belton. And I always referred to as Belton. I don't know if anyone calls it Boston. Everyone I ever heard calls it Belton. A number of companies and conservatives challenged the law. In a 5-4 decision, the Supreme Court struck down the law to determine the identity speak did not matter. The dissent pointed out corporation was entirely artificial. But of course, the decision set precedent for which Citizens United would further extend. Yeah. Good times. I'll now turn to Roberts Court's handling of cases involving voting rights. I note that a successful and self-confident democracy will do everything it can to encourage people to vote. When a legislative body enacts policies designed to make it harder for people to vote or discourage them from voting, it does so because it does not want them to vote. Well, that is ascribing, intent and motive, which isn't necessarily the greatest thing ever. So, there's that. It mistrusts and fears democracy. That is what Republican legislatures have done for a decade. They have ratcheted up identity requirements, conducted scare campaigns against immigrant voters. Like what? Rolled back early voting and absentee voting, which, has legitimate pros and cons. Early voting and absentee voting has pros and cons. The obvious pro of it is that more people can vote because not as many people have to stand in line. The con of it is that, things on the ground can change very rapidly. And so if you allow people to, say, vote over a 2-week period, things can change very rapidly in those 2 weeks. And it's a little unfair to the candidates because they didn't have as much time to campaign as they would have otherwise. So there's pros and cons. I don't really have a strong position on it, but it's not as simple as saying we should extend it because that comes with consequences too. Not every voter is voting with the same amount of voting information. So, there's something to factor into that analysis. The cumulative effect on the court's voting right prudence has made it much more difficult. It's not so much the court as the legislatures, but okay. Possibly the court's most disturbing attack on voting rights can be found in two decisions, which come close to eviscerating the Voting Rights Act. We're going to go a little bit into the history of the Voting Rights Act. The decisions and questions were both decided by 5-4. The first of the case was Shelby County. The second was Abbott versus Pratt. In Shelby County, an opinion written by Chief Justice, the court struck down the formula provided for in the law by determining whether states and municipalities had to get approval for any changes to their laws. The pre-clearance provision required 9 states and municipalities and 6 others to provide the Attorney General or a 3-court judge any change of voting rules that neither purpose of effect or discriminating. Shelby County turned on the question of whether African Americans in vote continue to face substantial discrimination. Conservative majority ignored the extensive legislative record compiled by Congress establishing the persistence of voting discrimination, stated that Congress's findings were out of date and that to require preclearance would violate equal dignity. Justice Ginsburg wrote a dissent, arguing that throwing out preclearance when it's worked has continued to work is like throwing away your umbrella in a rainstorm because you're not getting wet. I think there is a valid criticism here to be had that the VRA decision was not a conservative decision. I think there's a valid criticism to be had. If one of the things that courts are supposed to do is just interpret laws, and Congress gets to have any law at once, then Congress had the law at once. The power of Congress to do this is presumably sunk into some combination of the 13th, 14th, and 15th Amendments. And if Congress has a law, then, you shouldn't necessarily overturn it. So if you want to say that Roberts' court didn't come up with a conservative decision on that opinion, then, that's okay. I understand. I think you can validly say it wasn't a conservative opinion. It wasn't in line with what Congress said. And the equal protection argument, particularly the way the court framed it, was a little thin. Because the equal protection argument was basically, well, it is now a problem. But that's not the way the Constitution works either. It should have always been a problem if it was a problem, not just now. As it turned out, the concerns were justified. Since the demise, states and municipalities formerly covered by law have implemented numerous discriminatory procedures. Within hours of the decision, Texas announced its previously blocked discriminatory voting law would immediately go into effect. Local governments in Texas also made discriminatory changes. One state eliminated 2 city council seats in predominantly Hispanic districts and replaced them with at-large seats in majority white districts. I don't even know what that means. I'm breaking down on the literal English because he says one city eliminated 2 council seats in a predominant Hispanic district and replaced them with at-large seats in majority white districts. I'm very, very confused by this because I don't understand how that's possible. I don't understand how it's possible to do that. It's not a well constructed sentence. I'm struggling on the actual English. North Carolina got in on the act, passing an omnibus law, which is just what they call it when there's a whole bunch of stuff in one thing, including an ID requirement, elimination of same-day voter registration, 7-day decrease in voter period, and invalidation of provisional ballots cast at the wrong station. Okay. North Carolina municipalities followed suit. Shelby County opened floodgates, enabling state and local governments with the most egregious histories of discrimination to start discriminating all over again. All right. Well, I've been recording 56 minutes. My voice is kind of giving out, and I never really got over the Godwin argument. I never really got it over being Godwin. But I think we got the gist, right? We got the gist from this judge that they have many, many problems with the Roberts Court, and they want to, express them publicly and bash the entire, foundations of conservative legal jurisprudence, apparently. So, there's that. So, good times. Yeah. So if you have enjoyed this stream, thank you for the $39 worth of super chats. It really helps me grow. I really appreciate it. and really validates me. I really appreciate the super chat support. For the 53 of you who are watching this, thank you very much for joining me. And that's all. We will be on tomorrow night with Supreme Court React. And I don't know, I might stream later doing something, maybe some Phoenix Wright or something. So we'll see what's going on. And we'll see what happens next. So until later, my friends, cheers and goodbye.